I don't want to get in the way of shine. Oh, look at Tom. In regards to the motion, do we need to proceed on that, or are we?
I think we're going to have to be in agreement on the motion. It was a motion for a gag order, and there's going to be an agreement. And the state, specifically the attorneys representing the state of Tennessee as a defendant, as well as the defendant himself, witnesses or investigators are prohibited from posting on social media or providing traditional media and or social media accounts covering the case statements concerning or alleging the facts of the case. Your Honor, and doesn't prevent anything with media other than if the facts of the case cannot be discussed. And it includes the defendant.
Is that it?
Yes, Your Honor. It does contain the safeguards promulgated by Tennessee Supreme Court of what can be.
Yes. There was a case that, and I appreciate the state providing the cite to that case. It was a very, it was a good opinion on what to do and what not to do in this type of situation. I appreciate both parties' cooperation in regarding this. And I'll say this, after reviewing the motion and the case, I think not only to ensure the state's right to a fair trial, but Mr. Drummond also to ensure your right to a fair trial as well. I want to make sure that the parameters are put in place, because I know the media since 2000, I appreciate our media that are here. I want to just echo that again. I appreciate our media that is here. The media since 2000 has grown tremendously since that case was first decided. Things are a lot far different than it was a quarter of a century ago. So I think that, we get our news now from not only our television and our newspapers, but from our telephones. If y'all are like me, it's a habit. So I will enter this order at this time. Today's date is the 4th of September. I need a pen that works, though. I sure do. Miss Jessica, do you mind if I borrow that? Thank you so much. Is there any other matters we need to take up regarding the preliminary hearing?
No,
But aside from me ruling, I'm assuming. So
There may be one other issue afterwards.
okay.
Yes, sir.
Okay. I want to thank, before I make my ruling in this, I want to thank the attorneys today. I want to thank all of you for your devotion to this case and your work you've shown in this case here today. Appreciate the state and also the defense attorneys. I know that, and I appreciate Mr. Huffman taking this case, and Mr. Mason. I know this was something you were appointed to, but I appreciate your graciousness in taking this matter on. I do very much, and I appreciate all the parties for their testimony. I appreciate the witnesses that are here today. I want to speak to the family today. I know you heard a lot of things today, things that were not pleasant to hear, but I appreciate the fact that, for the most part, your candor has been respectful to this court, and I appreciate that you've shown this court respect. I don't want that to go unnoticed. To all of you, I want to say this. I know that at this time, this is not the trial today. This is only the first step in that next proceeding. The standard you heard that was presented is a probable cause standard, which means it's more likely than not. I am not making a finding of guilt or innocence today. That is not what is happening. I don't want y'all to leave and think, what did he just do? So I want you to understand that. It is still alleged as to who committed this offense, but I know it's not alleged that the loss that y'all have suffered. And I want you to know that my heart does go out to all of you. And in the days, weeks, months, and years to come, you will be in my prayers, because I know it's a long road to that. I want to thank, I don't want it to go unnoticed, but I just want to thank you for your respect you've shown the court very much. In regards to the matters today, the court has heard the testimony from all the parties, and in consideration of that testimony, in case number 25 CR 48067, the charge of first-degree murder, the court does find the probable cause regarding the murder of Mr. Braden Williams. In case number 48068, the charge of first-degree murder, the court does find probable cause in regards to the murder of Miss Adriana Williams. In case number 48069, the court does find probable cause in regards to first-degree murder in the matter of Mr. Matthew Wilson. And in case number 48070, the court does find probable cause into the case of the first-degree murder of Miss Courtney Rose. The court also does find probable cause in case number 48071 as to the charge of aggravated kidnapping of the young child and the possession of a firearm with the intent to go armed as a commission of a dangerous felony. Aside from the proof of the agent Tubbs, there was not any other proof put forward to show whether or not he is a convicted felon. So based on that, I'm not binding those matters over the counts 2 on 48067, 68, 69, and 70. But those are the only charges that will not be bound over. The remaining charges will be bound over. The 4 first-degree murders, the aggravated kidnapping, and the possession of a firearm with the intention to go armed during the commission of a dangerous felony. In regards to Mr. Drummond, I want to make you aware this is your notice for your circuit court date. Should your cases be presented to the grand jury on November 10th of 2025 at 9 a.m., you will appear before the Honorable Mark Hayes, the Circuit Judge for Lake County, Tennessee, on November 17th, 2025 at 1 p.m. Now, before we conclude that, I had heard that there may be another matter that needs to be addressed.
That's correct, Judge. When we were here previously, the defendant's girlfriend, Ms. Caitlin Speed, had requested, I indicated that she requested to have no contact order lifted so she could communicate with Mr. Drummond. The media seems to spin my words. Mr. Drummond did not request this be lifted. She requested it. So she has actually reached out to the district attorney, who's not in agreement, but she has indicated to the district attorney that she would like that portion to be lifted so that she can have communications with Mr. Drummond. And again, previously that was stated in the news reports that Mr. Drummond had asked her that, and that's not the case. Ms. Caitlin Speed was the one who reached out and wanted to have communication with Mr. Drummond. So we would respectfully ask for that portion of the no contact order to be lifted as it relates to Ms. Caitlin Speed.
Let me hear from you, Mr. Goodman.
Ms. Caitlin Speed did contact me. I talked to her about this. She did ask me to allow contact, to allow the restraining order to be lifted. I told her that I would be honest and tell the court that's what her wishes are, but I also told her that I would be opposed to this. I would be opposed to the restraining order being lifted. And, Your Honor, the fact is that she is a witness in this case, and there does not need to be any communication between the defendant and a witness. And in addition to that, she's also a member of the family of the victims, and we're concerned that there may be an issue there. The restraining order is for all family members of the victims, so we would ask that the restraining order stay in place.
She is the mother of this unborn child. I understand that she's being a witness. So he can't communicate regarding that portion. Again, she's pregnant with this child, and I'm sure they want to discuss matters of that, family matters.
Now, the problem with that is, there's no way for us to police that. There's no way to say, okay, well, you can talk to her about these issues, but you can't talk about the others. You know, it's not like we're gonna be there to monitor the situation, and say, oh, okay, stop talking, you can't talk about that. You know, so there just needs to be a restraining order that prevents all communication.
Now, they are clearly listening to every phone call that he makes. They can listen and monitor in real time the discussions, so they will know what they're talking about. And obviously, if he crosses that line and discusses facts of the case, that's an issue, but that can be controlled or at least limited in scope. So they are listening. They know what he's saying to her. I'm not sure how that would be inappropriate.
I think that the issue at hand is not whether or not it would be appropriate. I think the thing I have to consider in this is that, based on the testimony I've heard here today, it is very likely that she is going to be a witness possibly in this case. That's what I've gathered from the testimony I've heard here today. I am not restricting any conversations between him and his family. If she wants to communicate with his family to give him messages regarding their child, I am fine with that. But because of the fact that there may be an instance where Ms. Speed has to testify at the trial, that's the only thing that kind of puts me in a position to not feel comfortable amending the order at this time for that purpose. So what I will do is that I'll continue to let it remain in place directly between the two of them. However, he is completely allowed to speak with his family and his mother or father or whoever it is that wishes to talk maybe through her to him regarding the status of his child. If it were to be the case that she would not be a witness at a later date, I'm not saying that's not, well, I'm losing jurisdiction of this today, so that's something that if you want to discuss with Judge Hayes, I'm sure he, I'm not going to speak for him, but you could have the right to revisit that at that time. So I'm going to leave.
Just to clarify, you want to get third-party contact, so you're saying he may have third-party contact as it relates only to family matters. Of course, I know what you're going to say is it may be difficult to police that.
I want to clarify that as well, because I thought what you meant was he could talk to his family, and then his family could talk to her, not that they could be on a three-way call.
Absolutely not.
talking to one
Yes,
another.
yes, yes.
That's what I understood.
That is
And
my.
that has been an issue, and I want to clarify also, and make sure the defendant understands, that third-party conversations
Is the same.
are violations as well. He can't tell someone, go tell this witness that I said this. That's a violation.
He needs to be aware of that, and it appears that based on the testimony today, it should be aware that his phone calls are being monitored. So obviously, does the state oppose him talking to his family? It's not his family. It's just them attempting to relay messages concerning the case to Ms. Speed.
Correct.
So does that make any sense at all?
Yes, not relating messages regarding the case, but I'm assuming it's okay to relay messages regarding his child.
I don't mind that. I mean, that's something regarding his child, but it can't be anything regarding the case or the facts of the case. And I would just say that those are being monitored. Those phone calls are being monitored. So that's just something he'll need to understand for that purpose. Okay, so it will remain in place for that. Folks, this is what I want to do before we do anything else. Having found that these matters are going to be presented to the grand jury and the cases will be sent to circuit court, or should he be indicted, what I'm going to ask is that at this time, if the sheriff's department will take him back into custody and transport him back, he will continue to remain without bond in this case. And while they are doing that, I'm going to ask everyone to please remain in the courtroom. Before we are adjourned, folks, I want to again thank our law enforcement that are here today. I want to thank all of our law enforcement for the efforts they put into this case in protecting the courtroom. And to the families, again, good luck to each of you in the days to come. With that, folks, we're adjourned.
All rise. Court is adjourned.